lot of individuals and companies that wind up in disputes didn't really think about all of the protective measures they could have implemented in the first place to avoid that dispute. Two things really come to mind. Number one is always having contractual agreements prepared concerning everything the company's doing. And that means concerning the owners of the company, there should be shareholder agreements or an operating agreement for a partnership that's a limited liability company. There should be employment agreements for all employees of the company, even if they're at-will employees, to govern the terms of the expectations of the relationship between the parties. And then on top of that, externally, you're also going to want to have contracts for vendors, for service agreements, for anything that the business is performing with anybody outside of the company, there should be contracts as well. So you have the protective measures through contracts, but on top of that, documentation. So contracts and then documentation. And documentation means that if there are any issues taking place within a company, any issues involving a third party, it's imperative that everything is placed in writing. So disputes, disagreements, issues that maybe aren't a problem now, but could become a problem in the future, need to be written down with metadata, so through emails or put into a Word document, something that auto saves, so it's very clear that this dispute was properly thought out or properly documented along its journey.